purposes of the record, have each of you reviewed the exhibits? We ask that you look through to make sure. Are all of the ones that were marked for identification, have those all been pulled out of the file?
Yes, Your Honor. The court reporter approached me and asked me if those were the exhibits. I agreed that those were.
Do you agree?
Likewise.
Okay. So those that are marked for identification only will not go back with the jury.
I don't know whether those have been separated, Your Honor.
Have they been separated?
Yes, ma'am.
Okay, they are separated. You want to give them their final. There's your final copy of the jury instructions. Proof is now closed. Mr. Kimsey, do you have a motion?
I do, Your Honor.
During this time, close of defense proof, I move for judgment of acquittal as to first-degree murder. Your Honor, as with my previous motion, I don't believe the state has put on premeditation. I didn't believe they had put it on at the close of their proof. Your Honor, since then, my client has testified. He testified that there was no premeditation. That testimony has not been rebutted. Because that's the evidence on the stand. The state has said multiple times, premeditation. They keep saying it, they've not proved it. Again, the testimony of my client was that it was not premeditated. It was quick, it happened instantly, he pulled the trigger. That's not premeditation. And so I move for judgment of acquittal for first-degree murder.
Your response?
Your Honor, there's a genuine question of fact that is the province of the jury to decide. Mr. Foley has testified, and it's up to the jury to decide if they find his testimony credible. As the state listed out in the original motion for acquittal, to close the state's proof, there are at least 4 factors for premeditation here that the state believes proof has been submitted on. The procurement of a weapon, a statement of an intent to kill, and Mr. Foley states very clearly, I will drop you. Forgetting the other 2 at the moment, but there are multiple factors for premeditation here. His reaction after the shooting, his calmness, his demeanor, shooting an unarmed person. The state submits that despite Mr. Foley's testimony, there is 0 proof to corroborate his testimony that Mr. Shelton was armed. So there are at least 4 factors that can be set out for premeditation here. And respectfully, there is a question, more than enough evidence for this to go to a jury. So respectfully, we'd ask, as charged, first-degree premeditated murder for the intentional killing of Jimmy Shelton, go to the jury, please.
Final word?
There you are.
Okay. I have reviewed my notes from the previous motion for judgment of acquittal and have considered that in light of the defense's proof as well as the state's rebuttal proof, applied the applicable standards, and at this time I'm going to deny the motion. There is a genuine question of fact for this jury as to the state of mind of the defendant at the time of the killing. And so each of you has had an opportunity to present proof in your side of the case, and the court is going to deny. There still are factors present that could support premeditation depending on how the jury weighs the evidence. I think there's issues of credibility and weight that was completely within the province of the jury, and so therefore I'm going to deny the motion. Okay. Have each of you, do you have your jury instructions?
Yes, Your
And
Honor.
are we ready for closings?
Yes, Your Honor.
Okay. Anything that I need to take up before we bring the jury back in?
No, Your Honor.
Okay, let's bring them back in then, please. I will say this, with the rain, it is hard to hear. Mr. Kinsey had several people tell me they can't hear you, so if you could please, everyone keep your voices up. Do we need to put the microphone on the podium?
Yeah, when you come in, so
It is extremely hard to hear when it's raining. It's hard to hear anyway, but when it's raining, it becomes very difficult.